Abizer Diwanji and talk a little bit more about this. Abizer, hi, morning. Great to be chatting with you. Abizer, for a third straight cycle, the deregistration application for Tata Sons is still under examination. I mean, how much longer do you think this kind of an ambiguity can persist before it starts maybe affecting Tata Sons' capital or, governance decisions as well?
So I think, Aisha, RBI is looking at many aspects at this doing. One of it is that, the repayment of the loans happened after being classified as an upper layer NBFC. And the regulations for upper layer NBFC say that once you're classified, you remain one for 5 years. Now, I guess that is what one of the things that has been investigated, I presume. The other thing that would be, which is apparent, we saw the flip-flop in the regulation also, is what is public deposits? So public deposits are either, you take money from entities which take public deposits onto your balance sheet, or you take direct public deposits. And that's obvious. But where you have an equity contribution from a company which takes public deposits. And I think that was a little bit of a flip-flop that has been happening on the regulator side also. That how do you deal with issues like that? And I think ultimately, if it is public deposits, then clearly you are an NBFC. If you do not take any form of public deposits, you're not an NBFC. So that's fairly clear in terms of what comes out. So I think that possibly is the level of debate that is going on at the RBI level. Uh, to answer your question.
Sajid here. Of course, there is a debate on how to look at this entire public deposit part of it, but also from a company's point of view. If a company is trying to make efforts to ensure that it de-alienates itself from public deposits, is that a good argument to get itself deregistered as an NBFC? Because typically these kind of applications shouldn't be taking 3 years to decide on.
Okay, so Sajid, in my opinion, very frankly, I do not think that entities like Tata Sons are NBFCs taking public deposits in whichever form. And I'll explain to you why. If they would have directly taken public deposits, I agree with you. But if they have not taken direct public deposits and comes in the form of equity, etc., just look at what is the intent of an upper layer NBFC. The intent of an upper layer NBFC is to have better capital, better governance of that entity, and to make sure that depositor protection happens with near bank type regulation. If you do not have public deposits, then where is the question of that regulation requirement? And if that deposit comes through capital, so for example, it comes from an entity which has taken public deposits, then it is part of your capital adequacy anyway. You're required to maintain 15% at capital adequacy as an NBFC, which you're maintaining. Tier 1 capital within that is something which is a special requirement for upper layer NBFC, which is not required. So ideally, all deposit protectionist related rules, which now apply to upper layer NBFCs because they're considered bank-like, are not necessary in a Tata Sons case. So from a pure reading of the operations vis-a-vis the intent of the regulation, I don't really see a need for Tata Sons to be classified as an NBFC, but clearly the regulator knows better.
Right. Abizer, hi, this is Harsha. But what does this mean? I mean, what's the kind of message that RBI is sending out when it's putting, these kinds of policies out? Do you believe that practically the RBI realistically expects a listing, or is this a work in progress?
No, I think it's work in progress. So very clearly, I think RBI's stand has been very clear. So RBI has clearly been saying that we are evaluating this application for withdrawal of license. And clearly the rules are clear that if there is a withdrawal of the license, then Tata Sons ceases to be an NBFC. If it ceases to be an NBFC, any regulation around upper layer, mid layer, or lower layer does not arise. Now, because of that, RBI has currently classified Tata Sons as an upper layer, after which an application has come in. That is currently being investigated, and hence they are very clear in their circular to say that this is without prejudice to the withdrawal of the application. So RBI has clearly saying that we have not taken a call on that. But pending that call being taken, our status quo of Tata Sons being classified as an upper layer NBFC remains. And that is not wrong, because the criteria of an upper layer NBFC is somebody who has 1 lakh crore of assets, which factually Tata Sons has. So I don't think the issue is not whether you are classified as an upper layer or not. The issue is whether you are an NBFC or not.
And so the requirement of listing, is that an important thing here? I mean, even if you are assuming that RBI goes ahead and dismisses the application, the requirement of listing, is that a necessity for an upper layer NBFC?
If RBI, yeah, it's absolutely a requirement. It's a law that if you are an upper layer NBFC, then you need to be listed, because that enables better governance, independent audit, independent directors, etc. A lot more things come into play. So yeah, of course, and SEBI regulations come into play, which require that shareholder agreements get vetted every 5 years. So there are many regulations that come into play if you are a listed entity. But my view is listing should generally be governed by need and requirement rather than regulation.
Understood. Okay, I'm sure we will have lots more time to debate this. This seems like a very, very prolonged, long-drawn process. But Abizer, great to have you today on the show. Thank you so much for your time. Of course.